Hello, my name is Paul Labiner. I'm the senior partner at the law office of Paul Labiner, conveniently located here in Boca Raton, Florida. I can easily be reached at 561-998-2362, or you're welcome to email me at paul, P-A-U-L, at plabiner, PLABINERESQ.com. So if you find any of the information that I'm going to share with you today of any interest or helpful, or you'd like to discuss some of your personal issues with me, I'd be delighted to speak with you or email you, whichever may be convenient. You know, the purpose of my video today is really kind of to discuss, the differences between a will and a revocable trust. I know that gets a lot of discussion, and there's some misinformation, unfortunately, that many people may be viewing. But let me just basically give you some insight as it relates to why a will versus a revocable trust. Again, a will is nothing more than going through the legal process of proving somebody's intentions and proving their will at the time of their death. And for the most part, most people want to avoid that process. And for good reason. Number one, it tends to be a little bit more expensive, so people want to avoid the legal costs involved. It tends to be timely, depending upon the nature of the assets in the estate. You're getting involved in a legal process that tends to be cumbersome at times. So avoiding the necessity of having to go through probate generally makes sense. There's one instance where I can see that probate is a positive one, and that is really giving us the opportunity as legal professionals to negotiate, outstanding debt, credit cards, or any other liabilities. We tend to have a much more favorable stance to negotiate and reduce those outstanding expenses by going through the probate process. Although in many respects, the same thing can be accomplished through a revocable trust, but we have a little bit better techniques that we can be utilized through probate that is unavailable for the most part through the use of a revocable trust. So avoiding probate makes sense. It definitely is an opportunity to transfer assets more efficiently and private. So myself and many other attorneys in the South Florida area, and for the most part nationwide, will tend to advise and recommend to clients the use of a revocable trust in lieu of a will. Why a revocable trust? Well, a revocable trust does everything that a will does plus. It provides for an orderly distribution of the assets. It ensures that those assets are distributed pursuant to your wishes, just as a will would. However, there is no probate. Things transfer more efficiently. Things transfer less expensively. Things transfer much more timely than it would be through the probate process. So it makes sense to have a revocable trust in lieu of a will in most instances. The problem that I have found, frankly, is that having a revocable trust drafted is really just part of the equation. Unless your assets are properly titled in the name of your revocable trust, you have done absolutely nothing. You may have just avoided all of that cost and expense because all of your assets, if it's not properly titled in the name of your revocable trust, will go through probate. It may be transferred pursuant to your intentions designed in the revocable trust, but the avoidance of probate has not been accomplished. And in many respects, I blame the legal community for that, because many attorneys will draft documents inexpensively, but that's not the entire picture. You have to ensure that your assets are titled. And when I say assets, I'm talking about all assets. Your business accounts. If you have an LLC, you have to transfer your membership interest. If you have bank accounts and they're in your name individually, they need to be transferred in the name of the revocable trust. If you have a house, although it may be jointly titled, eventually that house also needs to be titled in the name of the revocable trust. Marketable securities. The exceptions are things like IRAs or pension plans or annuities or life insurance, which transfer by operation of law or contract, so those assets do not necessarily have to be transferred into your revocable trust. But all other assets need to be properly drafted and need to be properly titled in the name of the revocable trust. Can you avoid probate? Absolutely. You can have assets jointly titled between you and a spouse or a payable on death account. But is that the best way of handling your assets? Is transferring that wealth automatically to a surviving spouse or to a child the best way of ensuring that your assets are not depleted due to a lawsuit or creditors or divorce? More often than not, there are better ways of transferring wealth, other than just simply transferring it by operation of law. Call my office. Let's explore. Let's address and understand both the pros and the cons. I'd be delighted to meet with you. I'd be delighted to sit and chat with you at no cost. Please call me 561-998-2362, or by email, please reach me at paul@plabiner, PLABINERESQ.com. I look forward to hearing from you. Have a pleasant day.